The original motivation for the Ninth Amendment and its intended purpose could hardly be more explicit. On June 8, 1789, the First United States Congress was considering the amendments to the Constitution that would make good on the Federalists' promise of a Bill of Rights. James Madison rose to speak. He referred to what he called one of the most plausible arguments I have ever heard urged against a Bill of Rights. To wit, it has been objected also against a Bill of Rights that by enumerating particular exceptions to the grant of power, it would disparage those rights which were not placed in that enumeration, and it might follow by implication that those rights which were not singled out were intended to be assigned into the hands of the general government, and were consequently insecure. But, Madison continued, he thought that the danger could be guarded against. I have attempted it, as gentlemen may see by turning to the last clause of the Fourth Resolution. Madison was referring to the draft of what would become the Ninth Amendment, which in its final form reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." During the first century and a half of America's history, when federal restrictions on liberty were so few, there was seldom a need to invoke the Ninth Amendment. Only 2 Supreme Court cases from 1789 until the New Deal even mention it. But starting in the late 19th century, a competing approach, the presumption of constitutionality doctrine, was gaining supporters. The seminal statement on the subject was written by Harvard legal scholar James Thayer in 1893, arguing that courts at all levels should presume legislative acts were constitutional, putting the burden of proof on those who would argue otherwise. This would become the standard progressive position as well, explicated in later years by Louis Brandeis. It was a wonderful resource for those who wished to pass progressive social legislation. At the time Thayer wrote, the Supreme Court still held that economic freedoms, especially freedom of contract, were constitutionally protected, even though they were not expressly included among the first 8 amendments in the Bill of Rights. Numerous lower court and Supreme Court decisions had voided state laws because they violated economic freedoms. Most famously in Lochner v. New York, 1905. If the presumption of constitutionality doctrine prevailed, the logic behind those decisions could be repudiated. The ascendancy of the presumption of constitutionality doctrine had been signaled in 1931 in O'Gorman and Young Incorporated v. Hartford Fire Insurance Company, when Justice Brandeis wrote that the presumption of constitutionality must prevail in the absence of some factual foundation of record for overthrowing the statute. It was given an even stronger boost in 1934 in Nabia v. New York, when the court upheld a New York law that fixed the price at which milk could be sold, saying that if the laws passed are seen to have a reasonable relationship to a proper legislative purpose and are neither arbitrary nor discriminatory, the requirements of due process are satisfied. In 1938, the Supreme Court's ruling in United States v. Caroline Products made explicit what Nabia had left implicit and extended it to federal laws as well as state laws. It proclaimed a principle that came to be known as rational basis scrutiny. It was the presumption of constitutionality doctrine on steroids. In the words of Justice Stone, who wrote the court's opinion, regulatory legislation affecting ordinary commercial transactions is not to be pronounced unconstitutional unless, in the light of the facts made known or generally assumed, it is of such a character as to preclude the assumption that it rests upon some rational basis within the knowledge and experience of the legislators. Robert Levy and William Mellor have translated the legalese for lay readers. Unless a challenger can demonstrate that a challenged regulation is wholly irrational, that there is no possible justification, no matter how attenuated, for the government's action, the regulation will be upheld. The slender reed protecting economic freedoms left by Caroline products, that at least a regulation could be challenged in the light of the facts made known, was subsequently dispatched by the Warren Court in 1955. Rational basis scrutiny raised an obvious question. If any rational basis made a piece of legislation constitutional, what was left of constitutional protections for any rights that might be intertwined with commercial transactions? The court gave a vague answer in a footnote known to law students ever since as footnote 4. Exceptions to rational basis scrutiny may be justified. The court wouldn't even commit itself to language stronger than may for rights that meet certain conditions. One such condition is that legislation appears on its face to be within a specific prohibition of the Constitution, such as those of the first 10 amendments. A second is that the court might, but who knows, might not, take an interest in legislation that was manifestly corrupt, rigging the political process. The third possible exception might be legislation that reflects prejudice against discrete and insular minorities, specifically religious or national or racial minorities. The Federalists had been reluctant to include a Bill of Rights because they had worried that to enumerate some rights would eventually give an opening for government to take away protection of rights that had not been enumerated. That's precisely what Caroline did, with the added insult of making the court the arbiter of which rights are worth protecting and which are not.